Breach of contract occurs when a party fails to perform their obligations under a legally binding agreement, but not every breach gives the other party the right to terminate the contract or commence legal proceedings. A contract may be breached in several different ways. This can include failing to perform a contractual obligation, refusing to performing the obligation incorrectly, or indicating that an intention not to perform in the future. Breaches arise in a wide range of situations, including commercial agreements, construction contracts, service agreements, property transactions, employment arrangements, and supply contracts. The legal consequences depend on the nature of the obligation breached and the seriousness of the breach itself. Under Australian contract law, breaches are often categorised according to their significance. A breach of an essential term may entitle an innocent party to terminate the contract and seek damages. By contrast, a breach of a non-essential term may give rise to a claim for compensation without necessarily allowing the contract to be brought to an end. Determining which category applies requires careful analysis of both the contract wording and the surrounding circumstances. Another important concept is repudiation, which occurs where a party demonstrates that they no longer intend to be bound by the contract or are unable to perform their obligations. Repudiation can arise through words or conduct and may entitle an innocent party to accept the repudiation, terminate the contract, and pursue damages. Where the breach has occurred, a range of remedies may be available. The most common remedy is damages, which are intended to place the innocent party in the position they would have been in had the contract been properly performed. Depending on the circumstances, other remedies may include specific performance, injunctions, debt recovery, or contractual rights to terminate. Importantly, parties should exercise caution before terminating a contract. One of the most common mistakes in commercial disputes is assuming that a breach automatically justifies termination. If a party terminates without a valid legal basis, that termination may itself amount to a breach or repudiation of the contract, potentially exposing them to significant liability. Because breach of contract disputes often involve complex legal and factual issues, contractual interpretation, and significant financial consequences, understanding whether a breach has actually occurred, what remedies are available, and what termination is legally justified can make a substantial difference to the outcome of the dispute. Contact us today for a free 30-minute consultation with one of our experienced team of commercial litigation professionals, and let us help you protect your rights.